if I could, let me take you to a number of things, because several other senators have referenced Hobby Lobby. One of the things that Judge Briscoe was saying was sort of category shattering or precedent setting was the extension to a for-profit corporation, the recognition of a for-profit corporation that sells crafts and hobby materials as being a religious corporation. Previously, only incorporated churches or synagogues or associations explicitly nonprofit religiously affiliated organizations have been recognized. In the interpretation of RFRA, you choose to define person to include for-profit corporations. Help me with why you made that move.
Be delighted to, Senator, and thank you for the opportunity. I think I'd point to a couple of things. First, RFRA is a statute, and it uses the term person, and it doesn't define the term person. And when Congress doesn't offer us a specific definition, we go to the Dictionary Act, which Congress has passed for just these circumstances. And there it says persons include corporations. That's the law, as Congress wrote it. And if Congress wishes to change the law and say only natural persons enjoy the rights of RFRA, I'm a judge. I follow the law. But the law, as drafted, doesn't distinguish between natural persons and corporations. It includes them both. And the government, Senator, if I might just finish, conceded, as I recall, and my recollection may or may not be great on this, but as I recall, conceded that nonprofit corporations can exercise religion.
That's right. And that's exactly why this was seen as such a departure. There was a long-settled expectation that religious free exercise rights adhered to individuals, living, breathing people, and to nonprofit corporations. It was a big leap for it to, for the first time, apply to for-profit corporations. And I appreciate that the opinion of the majority and your concurrence referenced the Dictionary Act. But the Dictionary Act actually says, on its own terms, that it applies unless the context indicates otherwise.
Right.
And the reality is, as I think one of the dissents points out, all Congress was intending to do, as expressed by a number of members of Congress, was to simply restore strict scrutiny, not to open up a whole new line of free exercise rights for-profit corporations. So I think the context clearly indicated otherwise. And to simply say, all I did was pull a dictionary off the shelf, look it up, person can include corporations, we're done with the analysis, is in some ways tendentious, because the idea that a for-profit corporation could have religious free exercise rights was nowhere in the earlier case law that Congress explicitly intended to be the narrow purpose of RFRA. So does Congress's intent when it passes a statute, its clearly stated intent, have any relevance to your interpretation, especially where something like actually urges you to look at the context?
Senator, I'll offer you two thoughts on that. First, as I recall, sitting here, and I have to go study my books, but the Supreme Court in an earlier First Amendment case did recognize a challenge by an Orthodox Jewish shopkeeper to Sunday closing laws.
That's right.
That was a corporation, for profit. So respectfully, I'm not sure it's accurate to say there's no precedent for it. Second, I would say to you, the position you're advocating is a fine position, respectable position. It's a good position. It was adopted by precisely 2 justices of the Supreme Court.